It's Larry from 7th Stage Law School Prep with another stick-figure exam tip. This tip is about conclusions in IRAC, and the key here is don't start with them and don't avoid them. There's a middle ground here between jumping to early conclusions and never reaching them that you need to strike in setting out your answer on a law school exam. Let's start with not starting with conclusions. Sometimes you get the advice, instead of IRAC, to do CRAC. And the one place I've heard this the most is in Barbary in preparing for the bar exam. That can work there. I don't want to talk too much about the bar exam right now. But I think that you should avoid starting with conclusions if you do a full IRAC analysis for any even semi-ambiguous question where there's a decent argument on both sides. And this is for two reasons. One is if you have a professor who has very strong views about the right view as to the outcome of a given claim or defense, what if you're wrong? You've jumped to the wrong conclusion, and the prof is likely to dismiss the rest of your answer and not consider the work that you've put into it as fully as he or she might otherwise. Even if your professor is not like that, I think starting with a conclusion appears like prejudgment. Now remember, this is not an actual legal brief or an opinion or paper where you really don't want to hide the ball. You really do want to start with your conclusion. But a law school exam is a lot about process and trying to show the work in your answer. And here you want to remember that you're coming across with very little time a totally new fact pattern. And to suddenly have a fully formed conclusion for every single fact, even if it's ambiguous, is a little weird. So you want to actually show the process of doing the A here, the actual analysis. You want to show the process of actually dealing with the A here in doing a full analysis. I think the exception to this, and there are kind of two of them, are pretty unambiguous claims, and that in part depends on a decent reading of your professor. If he thinks something is not really in question or has indicated that during the semester, then don't spend a lot of time. Just jump to the conclusion because that's what he or she wants. I think also I've done a unit on kind of tapering your use of IRAC throughout an exam. As you begin to run out of time, maybe you want to do a short, fast IRAC. I have a format for that does involve front-loading the conclusion. And at that part, where you're doing pretty cursory analysis towards the end, or at least abbreviated, it's all right to lead with a conclusion. So that's one sin, just kind of jumping to the conclusion. Other students have a different problem where they just avoid the conclusion. They just want to provide analysis, or they want to show that they understand the rule and they can at least apply a rule and make arguments. But you need to stop being so wishy-washy, Charlie Brown. This is my Charlie Brown and his body, some cross between a snowman and E.T. You definitely want to be nuanced, but in the end you need to be decisive, because analyzing a claim or defense is very similar to the act of providing a client advice. So here are some typical phrases that are used by wishy-washy types. This is ambiguous. Or a court might find that ... I really hate this phrase because what a court might or might not do, that is the conclusion, that's your judgment. This is ambiguous is sort of recoverable because you can at least add a conclusion towards the end. It's not terrible. In fact, it's quite good to acknowledge that a question is close and has good arguments on both sides, but this needs to be followed by because ... and you still need to come to a conclusion. If you have a close case, I think a good phrase to use is the better view is X. And you can acknowledge the weaknesses of that view and still come to the conclusion that X is better than not X, whatever that conclusion might be. But in the end, just go for it. You know, the ball's got to roll down one side of the hill or the other. Another good phrase to use is party A would likely prevail because ... So these are nuanced phrases. They're not saying that this is absolutely likely to happen. All of this is sort of probabilistic, as would your advice to a potential client. would actually be. You can't guarantee a result that would get you disbarred in a lot of places. But what you need to do is just set out, and this is the better view. The better view meaning this is objectively where a court is more or more likely, in your professional judgment, to come out. That's the best that you can give, but you need to at least give that and not be Charlie Brown.